Now, we will now proceed to our second discussion session led by Honorable Mr. Justice G.S. Sandwalia, Honorable Judge of the Punjab and Haryana High Court and Executive Chairperson Services Authority.
Everybody. Justice Khanna who's given us an opportunity to be here in his hometown and interact with him.
So I'm thankful that Justice Arun Palli, in charge of Khalsa from Haryana, Justice Sridhar from Chandigarh, has also joined. Other members are from and secretaries of the DLSA, all who have come from long distances. The interactive session which we propose to do and as thought out is with a vision. The letter which is addressed to all of you, if you will realize, is the DLS have come at least from both the states of Punjab and Haryana. We have only got 50% of our representation here. The reason behind it is apparent that the ones who have been called are from backward districts, remote districts and mid-level districts. I can vouch that out of the 10, many are calling in the border districts. Like you have Taran, you will have Faridkot, Fazilka, Firozpur, Pathankot and Gurdaspur. The midsections are, you have Barnala, Moga and Mansa. The purpose is apparent. We are here for legal aid and the ones districts maybe were more prosperous as such. That is the reason that we have to see where we are going forward in the backward districts, how far we are reaching ahead. That seems to be the agenda. My sole and earnest effort will be here to interact with the officers who have come from the state of Punjab also. As we've been discussing, we are looking at it in a supervisory role. They are all based there. The interaction in the mornings with the paralegal volunteers showed the level of commitment, of course, but also the difficulties. Maybe like one gentleman, he and the lady said that nobody's taking us seriously. They said that you are part of the government. We've seen many come and go. My topic is the status of the implementation of the NALSA framework for the early access to justice at pre-arrest, the arrest and the remand stage. The second one is the under-trial review committees. And the third is the inspection of the prison legal aid clinics and reporting thereon. So as I have pointed out that, of course, we've also distributed our brochures to you, what we have done. As Justice Khanna pointed out, it is one of our weakest stage. An effort has been made to dispel and to put it in with you also that the advantage of having the police diaries to DD suspects and those arrested and during interrogation and earlier stages. We have a proper robust system that whenever a person is brought to the police station, the first reaction of a person who is there at the police station is a reaction of getting bewildered that what has happened to him. And as well, experienced police authorities can be a little high-handed. Punjab police is known to be exceptionally high on this category. We cannot blame them. They behave like, because after all they're dealing with a certain set of people which maybe we do not deal at every day level. It's very difficult to say that they have to have the same kind of soft touch After all, the man on the street will always behave as the man he encounters. The other man will only understand him as a person, because that is the only way he understands, the language which he understands. But this is where we have to step in to soften the blow. The leaflets and banners are in English and vernacular. We realized was in English and Punjabi. Suddenly, in the course of discussion, it comes that we are dealing with a large number of underprivileged people. In Punjab, you have a large number of migrants also. So it's something as we are sitting here, we seek to improve. It is for us to see that if we are going to publicize ourselves, at least we have to broadcast ourselves. We are really working from outside. They also have to know their knowledge. They are the first ones who are picked up. Police station will be the first ones you will see. POCSO cases also maximum. You will have migrant labor, which is always the one set of the accused. So I'll ask Madam Gagan from Muxar Sahib, could you just please elaborate, ma'am?
I am posted at Shri Muxar Sahib, Punjab. So far as legal aid at pre-arrest stage is concerned, though NALSA framework for early access to justice at pre-arrest, arrest and remand stage started in 2019, but due to COVID, this area had taken a back seat. Now, under the guidance of our Honorable Executive Chairman, Honorable Mr. Justice Gurmeet Singh Sandhawalia, the efforts are being revived and all the DLSs have been directed to conduct joint workshops with SHOs. In this regard, all the SHOs are being directed to prepare a special memo like arrest memo. जब भी कोई पर्सन पुलिस स्टेशन पे आता है तो SHOs को हमने डायरेक्शंस दी हुई हैं कि आपने उसको एक मीमो प्रिपेयर करना है कि उसमें आपने उसको बताना है कि यू आर इंटाइटल्ड फॉर फ्री लीगल एड एट द स्टेज ऑफ प्री अरेस्ट इटसेल्फ. वो मीमो जो है दैट इज बीइंग काउंटरसाइंड बाय द अक्यूज्ड पर्सन. Defense counsels are available at headquarters and retainer advocates are available at the police stations on call. Whenever any person is being brought to the police station, anticipatory bails are being filed by the legal aid defense counsels. Unnecessary जो arrest हो रही थी पहले section 41 CRPC था, now that is 35 free BNSS. अगर उसकी violation होती है तो legal aid defense counsel जो है वो accused को inform करते हैं कि whether they have given you notice under this provision. अगर notice नहीं दिया होता तो उस stage में भी वो उसकी help करते हैं और anticipatory bails भी वो move करते हैं. Apart from this, regular seminars are being conducted in the villages to tell the litigants or general public to know about their legal rights.
The panchayats are also a necessary kind of a support system. Can we really go in without them? Like are we only dependent upon like block development or district development officers? Or you think that the elected representatives as such, do they are more helpful in breaking the gap? Like in the morning, paralegal volunteers said that they don't take us seriously. But do you think this elected system, if you have the panchayats and the sarpanch with you, are they more helpful in organizing camps and seminars in villages, or it is better that we go on our own? What is your take on it?
हम being secretaries वहाँ जाते हैं तो गैदरिंग नहीं हो पाती वहाँ पे. जो सरपंचीज हैं हम डे बिफोर जब भी हमने जाना होता है उससे एक दिन पहले हम उनको इन्फॉर्म कर देते हैं कि नेक्स्ट डे हमारे DLB ने या सेक्रेटरी ने आना है, तो वो अरेंज करके रखते हैं. वो गैदरिंग भी सरपंचीज के कहने पे ही लोग आते हैं, अदरवाइज दे डोंट टेक अस सीरियसली लॉर्डशिप्स.
Organized in coordination with the police authorities or otherwise?
लॉर्डशिप जो हमने प्री अरेस्ट और रिमांड स्टेज वाले करने होते थे हम कंसर्न जो लोकल SHOs होते हैं वी आल्सो इन्वॉल्व हैं. अदरवाइज जो अपनी जनरल लीगल अवेयरनेस होती है तो उसमें भी डोंट कॉल SHOs. तो गैदरिंग जो होती है वी टेल देम अबाउट देयर ऑल द राइट्स, ऑल द स्कीम्स ऑफ NALSA and all the other compensation schemes etc.
And what about the sensitization programs of the police officers regarding the pre-arrest?
Lordships, we are conducting monthly meetings with the SHOs. When I was posted at Jalandhar, there is Philor Academy, that is the centralized academy of Punjab. तो वहाँ पे I used to go weekly. वहाँ पे all over Punjab से जो police officials, DSPs और SHOs they used to come for the trainings. और वहाँ पे सारे पंजाब के जो SHOs ये नहीं है कि आपका प्री अरेस्ट स्टेज पे अरेस्ट स्टेज पे और रिमांड स्टेज पे उनका लीगल एड का राइट है।
The normal routine, if you find that the police are using a very aggressive force when the person is being detained at the initial stage, what is the procedure, or how does the system step in?
Lordship, we have displayed the names as well as phone numbers of LADCs in all the police stations. Even we are under the process of appointing paralegal volunteers at police stations. वो उनको वहाँ पे वो इन्फॉर्मेशन दी होती है और वहाँ जो भी कोई पर्सन जाता है तो अगर PLV के नोटिस में आता है कि पुलिस वाले जो एट्रोसिटीज कर रहे हैं तो इमीडिएटली ही और शी इन्फॉर्म्स द लीगल डिफेंस काउंसिल एज वेल एज द सेक्रेटरी DIS। वो जेल विजिट जो जेल्स में भी जाता है, पुलिस स्टेशंस में भी होता है, ऑल दी कोर्ट्स वो हम सबको डिस्ट्रीब्यूट करते हैं वो ड्यूटी लिस्ट।
Regarding the LADC, which that Madam from Shilpa from Taran, can you please just brief us a little, because as we had discussed that you said that in Taran there are, and Moga also you told that large number of NDPS cases are there, right? With the system, because they feel that the LADCs is another set of a prosecution, and maybe the conviction rate anyways in NDPS, especially in commercial, the escape route is very minimal. So the general impression of the field is that the LADCs are not helpful in the end and you mount to a conviction. How do we break this mold? Because after all, there are three categories of the recoveries. The moment we come into the commercial quantity, even for the best of the lawyer, it's an almost impossible task until there is a major lacuna by the investigating agency. Apart from the fact, once there is a direct conscious possession recovery. So how do you feel?
Shilpa, Secretary DLSA, Taran, Punjab. Sir, regarding this, sir, I want to apprise that Legal Aid Defense Councils का सर एक हमने ड्यूटी रोस्टर बना रखा है जेल्स में जाने के लिए। जब उनका सर पर्सनल लेवल पे इंटरेक्शन होता है विद एवरी जेल इनमेट, तो उनका जो ट्रस्ट है वो बिल्डअप होता है लीगल एड डिफेंस काउंसिल्स के साथ, एंड दे कैन इंटरेक्ट एंड दे कैन टेल अबाउट ईच एंड एवरी केस टू देम कि उनकी आगे इसमें स्टेजेस में क्या बनता है। जैसे NTTS के केसेस में वो कन्विक्शन रेट रहता है, so they can interact with them and they can sensitize them about all that. And but sir, जो आगे भी अब देखा गया है, जैसे अर्लियर रिमांड स्टेज पे भी हमारे रिटेनर एडवोकेट्स अपीयर होते थे कोर्ट्स में। अब सर लीगल एड डिफेंस काउंसिल्स के आने के बाद हमने चेंज देखी है सर। रिमांड स्टेज के बाद जब रिटेनर्स अपीयर होते थे, एट दैट टाइम सर जो रिमांड स्टेज के बाद हमारे प्राइवेट काउंसिल्स अपीयर होते थे मोस्टली इन ऑल द केसेस, और लीगल एड डिफेंस लीगल एड जो हमारे स्कीम्स हैं उनको नहीं ज़्यादा परस्यू किया जाता था। बट आफ्टर द इंट्रोडक्शन ऑफ लीगल एड डिफेंस काउंसिल स्कीम डिफेंस काउंसिल्स के ऊपर, क्योंकि सर अब जो SOPs आई हैं हमारे पास पंजाब में, उसमें उनकी ऑलमोस्ट डेली बेसिस पे विजिट्स हैं एंड दे आर इंटरेक्टिंग विद इन ईच एंड एवरी बैरक विद ईच एंड एवरी जेल इनमेट। तो उनका सर कहीं ना कहीं जब हम भी जेल विजिट्स करते हैं तो बात करते हैं, उनसे इंटरेक्ट करते हैं, तो कई बार केसेस ऐसे भी हमारे सामने आते हैं जिसमें हमें ये रिक्वेस्ट करते हैं कि हमारे प्राइवेट काउंसिल अपीयर नहीं हो रहे हैं और हमें लीगल एड डिफेंस काउंसिल के ऊपर ज़्यादा ट्रस्ट है, आप ये केसेस उनको ही दे दीजिए। सो नंबर ऑफ एप्लीकेशंस फॉर अवेलिंग द लीगल एड हैज इंक्रीज्ड इन
regarding subdivisions, because all of them are based in the district.
Yes sir, जनरल कंप्लेंट यूजुअली कम्स कि जो रिटेनर्स हैं हमारे या पैनल एडवोकेट्स जिनको हम केसेस मार्क करते हैं वो यूजुअली कम अपीयर होते हैं कोर्ट्स में। बट उसके लिए सर जो हमारे चेयरपर्सन DLSA हैं उन्होंने इंस्ट्रक्शंस पास किए हैं, जो सब SDJMs होते हैं, सब डिविजन जुडिशियल मैजिस्ट्रेट जो कि चेयरपर्सन भी होते हैं सब डिविजनल डिस्ट्रिक्ट लीगल सर्विस कमेटी के, उनको इंस्ट्रक्शंस पास हैं कि उनकी मंथली मॉनिटरिंग की जाए और वो मॉनिटरिंग करके सर चेयरपर्सन के सामने पुट की जाती है। एंड इन द सेम वे सर लीगल एड डिफेंस काउंसिल्स के भी जो हमारे काउंसिल्स हैं जब लॉर्डशिप वो अपीयर होते हैं कोर्ट्स में, कोर्ट्स के सामने एवरी कोर्ट गिव्स देयर परफॉर्मेंस रिपोर्ट आफ्टर एवरी 15 डेज टू द चेयरपर्सन DLSA, और मंथली मीटिंग्स कॉल की जाती है, उनकी प्रॉपर मॉनिटरिंग की जाती है सर। एंड इफ एनी शॉर्ट कमिंग्स दैट इज डिस्कस विद देम, एंड इफ कोई भी लीगल उनका लैकुना फील होता है तो चेयरपर्सन DLSA डिस्कसेस ऑल द मैटर्स विद हिम। वैसे ही नहीं, अगर कोई भी एक्यूज्ड ऐसा है जो लीगल किसी भी काउंसिल की एब्सेंस में अपीयर हो रहा है तो इमीडिएटली लीगल एड डिफेंस काउंसिल्स को बुलाया जाता है। इवन द NAP courts also sensitize them about these schemes, और जब भी हमें ये लगता है कि कोई भी काउंसिल अपीयर नहीं हो रहा है, एनी केस इज नॉट रिप्रेजेंटेड बाय अ लॉयर, इमीडिएटली लीगल एड डिफेंस काउंसिल्स अपीयर होते हैं रिमांड स्टेज पे भी एंड एज वेल एज दे फाइल द बेल एप्लीकेशन।
Area of concern, you would say, that which needs to be addressed regarding bridging the gap as such regarding.
लीगल डिफेंस काउंसिल्स की रिक्वेस्ट भी है सर, उसमें ये है कि सर कि एक तो उनकी सैलरी पार नहीं है विद द अदर डिस्ट्रिक्ट्स। सर जैसे बैकवर्ड एरियाज जैसे हमारे जो सी डिवीजन वाले एरियाज आ जाते हैं पंजाब में, उनकी सैलरी चीफ की 70,000, बट इफ वी कंपेयर इट एट जलंधर दे आर गेटिंग 1 लाख रुपीज सर। तो वहाँ पे जब कंपैरिजन आता है सर, एज इन तरन दे आर मोर ऑफ NTPS केसेस एंड आवर LADCS इज हैंडलिंग ऑलमोस्ट अबाउट 800 केसेस। बट अगर वही कंपैरिजन जलंधर के साथ किया जाता है तो आई थिंक दे आर हैंडलिंग 869 और 870 केसेस। सो इन दैट केस समवेयर सर उनको थोड़ा सा परफॉर्मेंस में गैप आता है सर वहाँ पे। So that is their request. And the second request is that their term should be, sir, term उनकी जो है एक तरह ही statement है सर, उनको यही नहीं पता होता कि उनकी next term repeat की जाएगी कि नहीं। ऐसे तो नहीं होगा कि next year में किसी और LADCS को वहाँ पे appoint कर दिया जाएगा and they would not be having anything in their hands thereafter.
After all, we will only increase or the extended term provided what feedback we get from the district judge. They can't take it for granted that once they are appointed that they are for good. So that assurance or that kind of thing you have to convey to them, that basically the performance is up to the mark. They can continue because they are going to get now with this kind of a level, they get a recognition at the district level. We had a very strange what you call situation when this scheme was being put in place. We got a lot of letters from district bar associations saying that this should be disbanded. He says that this is going to badly affect our earnings. It was like a kind of a move which is still there, I'm told, like mediation. There's a general concept that the lawyers feel that when something new is introduced, that's going to directly affect or impact them. That is what but well-heeled people, they always engage private counsels. Do you have any issues that at some stage even persons will be provided this facility? Also a private counsel is being engaged, then what happens exactly?
Whenever sir अगर ये होता है कि LADCS के काउंसिल हम अपॉइंट करते हैं और साथ में प्राइवेट काउंसिल भी कोर्ट में अपीयर हो जाते हैं, तो हमें कोर्ट एक रिपोर्ट भेज देती है दैट प्राइवेट काउंसिल इज अपीयरिंग। नहीं तो साइमल्टेनियसली एक एप्लीकेशन हमें लीगल एड डिफेंस काउंसिल भी दे देते हैं दैट द प्राइवेट काउंसिल इज अपीयरिंग एंड दे विथड्रॉ देयर वकालत नंबर फ्रॉम दोस केसेस।
Then they withdraw.
Yes sir. Yes, so the most important thing what we have seen is that they have to go for jail visits and some traveling allowances should be provided to them so that from the salary they are not able to
entail traveling expenses for these people, which they are a little chary of, taking on extra. Even rather sometimes even a secretary, legal service authorities, because some of the districts, very few of course, they do not have the jail in the same district. So the visits are also comparatively lesser, which we need to more monitor to make sure that their visits are more regular. Just because the district doesn't have the jail and the distance is there, the persons at least lodged inside shouldn't have a feeling that they just got left out or marginalized. The aspect as you were pointing out, we can inform them also. Of course, Professor. So you have to kind of assuage their feelings that what we are giving you is we are giving you because where you are based, right? So you have to also impress upon them that it's on a basis of some criteria that we are giving you a little lesser amount, because otherwise this feeling that maybe you are getting less than what you paid in a bigger district. If you have to tell them and advise them, because they will only look at it from their monetary considerations to that aspect that yes, why not at par? Equal work, equal will. There is a basic principle in India, I think, readily accepted, but that is there. The next topic which we can touch is the under-trial review committees. As also pointed out from the figures, jail inmates are constituting the significant population which require free legal assistance. The convicts are maybe just down to 25%, rest are all under trials. There are certain issues also which we are facing is that even when a order of bail is granted, sometimes conditions are imposed of heavy sureties, which sometimes they find it difficult to fulfill. I would say that really can't be really faulted at that stage, but sometimes even we also, even when we are suspending sentences in criminal appeals, we find that people are coming from out the state. Sometimes in Haryana, people are from UP, some are from Nepal. We do feel that maybe once they're released on bail, they will not come back when the main appeal is heard. So maybe the courts also have the same kind of thing, but we'll have to, there's a very balancing factor which has to be played, that whether personal bonds can be accepted and maybe people can be released on that. Mr. Vijay Singh, can you just also just give us a little feedback on this under trial?
Other parts of the country. And mainly after the person are getting bails also, they are unable to furnish the bail bonds due to financial constraints. And when any application is moved, they press that their personal bond should be accepted. And I am guiding with the applications to the courts concerned that their application for personal bonds be accepted, so that the person who have been granted bail, they can be sent out of the jail. And actually this scheme was started with the letter of Honorable then Chief Justice of India, Justice R.C. Lohoti, in a case, in a public interest litigation of 5/7/2013, and the main issue was overcrowding in jails. And overcrowding in jails, legal jails the bड़ी problem खड़ी कर देती हैं उन्होंने. Actually, jail inmates को यही problem आ रही है कि they are unable to furnish the bonds which they are required to do as per the direction of the court. Suppose
They go from the occupancy. If you see the occupancy rate, we've got data is at Punjab is 115%, right? Whereas Haryana jails are operating at 121.6 capacity. I'm sorry, Justice Palli, I'm also barging into your state, and Chandigarh, Madam Gill, is also at 106.7%. So the strength of under trial prisoners in Punjab stands at 79.6, Haryana stands at 76.8, and Chandigarh at 66.3. Whereas Himachal, Brother Tarlo, with your permission, it is 64.2, right? So the UTRC meetings in 24, if we notice, we were able to identify around 2694 prisoners, and we were able to get 1713 released. And this is a comparative increase from 34.26 in 23 to 63.58 in 24. I have to say that this is done with the credit goes solely to Justice Khanna. The moment he took over in December, this was his first issue in discussion when we met by way of video conferencing for the first time. So this is one thing. I think we have to give him a hand on that. I can't divorce myself from the officers of state of Haryana. So a little bit of interaction what just now the state Punjab, some officials have said. So one or two please, somebody coming forward and tell us exactly how your LADCs are functioning. For state of Haryana please, some officer please volunteer.
Namaskar Lordships, I am Neha Sharma, I am Secretary DLSC Shimla. Of course Lordship, there are some bottlenecks, but these are to be addressed at the very initiation. When the under trials are in the courts, at that time when Chief LADC and the other legal aid defense system, they approach and they represent them. At that very stage, they are being told as to what offence they are in, and obviously all the requirements are being taken up regarding the free legal aid services which are to be provided to them. Lordship, but in NDPS cases, obviously the stakes are larger because there is a very serious offences which are being committed. So accordingly, they are being guided by the LADC system.
Which are more affected in Himachal, which would be pertaining to NDPS matters.
Lordship, mostly the district which are bordering the other states. For example, in Una, the cases are in Shimla. Then in Kangra also, there are cases.
Has the what you call contraband in the sense in the manner changed, or is it the same conventional contraband? Or there is a slight switch to synthetic?
Lordship, there are some synthetic contraband cases as well.
Okay, they are coming around.
Yes, Lordship.
bulk trade is in Punjab. ਮੇਰੇ 5-6 ਮਹੀਨੇ ਦੀ ਸਰਵਿਸ ਦੇ ਵਿੱਚ ਮੈਂ ਇਹ ਦੇਖਿਆ ਕਿ ਸਾਡੇ ਹੈਲੋ ਜਿਹੜੇ ਮੀਡੀਏਟਰਸ ਹੈ ਸਰ 10 ਜਾਂ 12 ਮੀਡੀਏਟਰਸ ਹੈ ਉਹਨਾਂ ਨੂੰ ਇੱਕੋ ਹੀ ਕਮਰਾ ਦਿੱਤਾ ਗਿਆ ਤੇ ਉਹਨਾਂ ਦੀ ਟਾਈਮਿੰਗ ਕੀਤੀ ਗਈ ਹੈ ਕਿਸੇ ਨੂੰ ਘੰਟਾ 11 ਵਜੇ 12 ਵਜੇ ਇਤਨਾ ਉਹ ਦੁਪਹਿਰ ਤੋਂ ਬਾਅਦ ਉਹ ਕਈ ਵਾਰ ਲਿਟੀਗੈਂਟ ਜਿਹੜੇ ਸਰ ਦੁਪਹਿਰ ਤੋਂ ਬਾਅਦ ਨਹੀਂ ਆਉਂਦੇ ਜਾਂ ਉਹਨਾਂ ਨੂੰ ਟਾਈਮ ਜਿਹੜਾ ਸੂਟ ਨਹੀਂ ਕਰਦਾ ਤੇ ਮੇਰਾ ਖਿਆਲ ਹੈ ਕਿ ਹਰ ਜਿਹੜਾ अपना mediator है उसमें separate room मिलने चाहिए सर.
Mediation is an issue, as is pointed out by Justice Khanna also, especially at 138 matters. Mr. S.P. Singh is here. He was the district judge at Gurugram before coming here. I happen to be the inspecting judge at Gurugram. Interestingly, as pointed out, we have 1.60 lakh cases of Section 138. Being the hub of Haryana. Multiple cases are filed by finance companies, big companies, on EMI basis. One check bounces, they will file 3, 4, and the number of complaints have gone up tremendously. The biggest problem which we were facing was the lack of service. Many of these people, the persons whom the loans have been given, they are not residing in the state of Haryana. So service is not being affected, and our courts have got clogged with this 1.60. Regular.
Otherwise they don't take us seriously, Lordship.
These workshops on rights of arrestees and corresponding duties, are they then facing?
Your Worship, like to say that we are proud of the fact that Mr. Justice Khanna, Sanjeev Khanna, is from District Chamba, and we are proud of him to be justice, as well as he is going to be the CJI of India. And we feel very proud, and we feel very humbly, you see here in the Raji itself. And whatsoever so far ours, this LADC scheme is concerned, Your Lordship, I would like to, firstly I would like to say a quick data, just for your appraisal please. That our office of this Legal Defense Council, it was established, it was started on 16th May 2023, and till 3rd of October, I have got the data, till 3rd of October, we have got 100 cases, session trials, that is NDPS 42, session trial 29, POCSO 14, drugs and cosmetics 1, appeals 10, family courts 4, and total 18 cases have been disposed of, and pending session trials are 82. And so far the magistrate trials are concerned, there are pending 86 trials. I'd say the moment we took over as a Legal Defense Council, the things have totally changed in District Chamba, though it's a aspirational district of Himachal Pradesh, which is in fact poor.
What is the strength?
3 assistant defense counsel.
And how many cases do you have all across?
186.
186.
186, Your Worship.
And out of them, the session trials and the
Session trials are 100, Your Worship.
right.
And 86 are the magistrate trials.
And do you have something like a subdivision also, which in the hill states will be more difficult?
Oh, we have got subdivision Daraji and subdivision Tisa also, Your Worship.
So
But in those, there we do not have any defense counsel.
so
we have got the remand counsel there.
You have got remand counsel.
Remand counsel there in Daraji, as well as in Tisa, Your Worship.
Okay. So for sessions trials, necessarily then matter would then eventually
District Chamba.
to Chamba.
Yes, Your Worship.
Okay, so the initial part will be looked at.
And Your Lordship, what I would like to say, there are 2 or 3 difficulties which we are facing. One is that is regarding to digitizations. Digitization means, Your Lordship, that when we have to, now we have a jugaad. Jugaad in the sense that we have just, being a litigant, we file the cases, any appeal or any bail applications. And as a legal, we are not filing it as a legal defense counsel, but as a litigant. So I think so far the data of this legal defense counsel is concerned, it will be very easier because in the program itself, if it is fed, we will be coming to know how many cases are there, what is their progress throughout India. And Your Lordship, we are connected with, in Himachal Pradesh, we are now, all the chiefs and deputy chiefs are connected. Even at the PAN, even at the All India level, all the deputy chiefs and chiefs are connected now, or through WhatsApp. We are getting the latest cases, whatsoever is happening in Tamil Nadu, whatsoever is happening in Assam, whatsoever is happening in Punjab, we are getting updated itself. And so we are able to provide the better services. Now the faith of the people, we have got definitely, I could definitely say that Legal Aid Defence Council system has put a revolutionary change in this criminal justice system, because now the people are coming up. Because whatsoever our assistant legal aid defence counsel.
How do you say it's better than the earlier system? There was already a legal aid system already.
There was
right.
There was difference is, Your Lordship, that earlier what happened? They used to do the private cases also. They were
total devotion.
It's a total devotion, and the people and whatsoever is assistants and the chiefs and the textile system, and they are getting the best stuff in Himachal Pradesh. I can say that has improved the system, because
the committee. So therefore,
definitely,
he knows which of the persons is appearing on the criminal side.
Your Lordship. And then make a revolution change. That now the under trials, because we have got the assistants who go 4 days in a week to the jail, and as a chief also, I go for 2 days in the jail, one for the legal awareness camp and one for the others, just interacting with the under trial prisoners and the convicts also.
That's very reassuring, at least in the state of Punjab, because the chiefs thought that now that they are chieftains, so therefore they said that we are not going, the assistants have to. So therefore we have to make sure that that's a good factor, that you're going on your own.
You have to interact with the family members of the deceased.
Yes.
There's some bottlenecks if somebody wants to have a problems that people are not being released because they are involved in multiple cases. So that is one of the problems, or it's a bottleneck we can say. Then the second bottleneck is there is involvement in heinous crimes related to drugs and gangs. So we're not sure that the same problem would be there in Himachal, because every state is a peculiar, and it also maybe even depend even from area to area. Like in Punjab, from border districts as pointed out, you have different problems and different challenges. You come to the urban areas, the challenge is totally different, and the rural areas is totally different. So please, can you just elaborate, ma'am, and please introduce yourself. Of course, as just now pointed out from the officer from Tarn, but now in Himachal also we cannot particularly discount the fact that there is the drug trade is there in a very large aspect. So which are the districts which are more affected in Himachal, which would be pertain to NDPS matter? What we call contraband in the sense in a manner changed, or is it the same conventional contraband and the tourist centers and more activity in that time? The strengthening of the legal aid kind of we put in a mechanism of a 3-tier system that how and the manner in which a person is brought to jail, what are his rights, and at what stage he comes into contact with the PLBs at that stage. Madam, the additional secretary, she will apprise you a little on how the system is put in. I had the occasion to visit Ludhiana district jail during inspection, the annual inspection. So after that, I realized that there were certain issues which needed a redressal. So we worked on this. Please, Madam Secretary.
Namaskar,
Yes, sir.
Smriti Dheer, I'm Additional Member Secretary, Punjab State Legal Services Authority. Lordship, though the NALSA's prison SOP on prison is already in place, but after Lordship's inspection in Central Jail, Ludhiana, Lordship had identified certain issues which were, though despite the SOP, the issues were not addressed properly. Thereafter, on Lordship direction, an SOP was prepared by PALSA. In this, we have evolved our own 3-tier mechanism. In the first tier, what is there as to the entry point? There, the convict PLB has been directed that the moment a new inmate enters the jail, at that very entry point only, that very inmate would be apprised as to his legal right, that he has right to avail the free legal aid. So that, because number of times it has happened that once the person enters the jail, he goes to the barracks, then his mind gets influenced by the views of the other inmates in the barracks. And then he has his apprehensions कि सरकारी वकील है, अच्छी proper services नहीं मिलेंगी, and उनको ये पता भी नहीं होता कि free legal aid का भी कुछ concept है. Thereafter, since at the entry point only he has been apprised as to the legal aid, and there he has been made to sign on the entries made in the entry point register, and it has been countersigned by the PLB and the inmate. Then the second tier comes the next day when the jail visiting lawyer, he visits the jail. At that time, he's been given the list of the new inmates. That jail visiting lawyer again apprises all those new inmates as to their legal, free legal aid concept. And then if they have their change of mind, so they can apply. Because many times it has also been seen that during the inspections of the administrative judges, inmates raise their concern that we are not aware about the legal aid, हमें तो पता ही नहीं है, हमें तो किसी ने बताया ही नहीं है. To plug in that issue, so we have done a 3-tier barricading. Like on the first tier, we take the counter signatures of those very inmates that you have been apprised. In the second tier, when the jail visiting lawyer comes, he apprises, then again the counter signed by the jail visiting lawyer. Then in the third tier, it is the secretary in the new SOP. The secretary has been mandated that they will visit every jail once a week. So during this very period of the once a week, in a week, the inmates, the new inmates, they will again be apprised, and they will be apprised that even if they are not even satisfied with the conduct of a private lawyer, there is no bar. They can at any point of time they can avail the free legal aid services. Lordship, even we took cue from that campaign of the restoring the youth, that we have added in the in our SOP, that at the entry point only, the PLB will identify whether any new inmate is a juvenile, so that there is no need, a kind of a machinery has started, that at that very point itself we identify if there is a juvenile, so the further course of action is started at that point itself. And Lordship, in this, in fact, Lordship, in this, the new SOP, what we have done is, as to the video conferencing facility, though in the NALSA's SOP, it was that the interaction with the jail inmates, that would be done, that would be facilitated through the video conferencing which is installed in the judicial complexes itself. But in the Punjab State Legal Services Authority in 2023 and 24 only, we have installed the video conferencing facility in all the DLSAs to facilitate the interaction of the LADC's councils, and even for the private councils also, we are providing this facility that if they want to interact with their inmates, they can do it. And one more, we have devised one more, since there was a concern at the subdivision level, there were the concerns at the time of inspection which was voiced there, that the inmates whose cases are tried there at the subdivisions, they say कि भी नहीं जी हमें तो लीगल एड मिलती है, बट हमारा तो पैनल लॉयर कभी आता ही नहीं है, हमें तो पता ही नहीं कि हमारा केस क्या है. So we have directed them that the moment the case has been marked to a panel lawyer who is working at the subdivision level, it is mandatory for him to visit the jail for in first 15 days. Though first 7 days, though we have proposed that this time gap should be shortened to 3 days. So it has been mandated, and
this also aspect just surfaced when we were preparing for ourselves for this session. So it's only that when we realize that you put a person away and the lawyer is not coming in for even 7 days, every day counts for a person. So we said that this is too much, even if it's not a let us reduce it to a period of 3 days. The person has to be apprised of his legal aid at the earliest. We also have identified that there were 55 children who were living with their mothers in the jail. So we are providing them elementary education, and below 3 years there has to be a creche facility. This is all part of the SOP we have kind of drawn. With one concern which I have faced, or which I, on the judicial side, I did notice, the state of Haryana is in a better position. The state of Punjab is a little not really up to the mark on this. This is the issue of premature releases. Every state has its own policies, as we noticed, but the state of Punjab does not, get the verifications done, especially where people are involved in cases from outside. The district magistrate's report doesn't come. The man has undergone his 14 years or 15 years, 16 years, and he's still awaiting a release. So this is the kind of a redressal system. We had a small order also passed, whereby the CGMs were empowered to release persons on bail on an interim basis till the DM decides, provided he has undergone the minimum as per the policy. So we are trying to enforce that, but we can say that sometimes CGMs are a little reluctant to do that, especially in cases, of course, because of heinous crimes. But it's a little sorry state of affairs when you go and visit and you find that the man has done his 14 to 16 years as per the policy, is deemed to be released, but the matter is just pending consideration with the DM concerned. So this is a matter of great concern. In Haryana, they have regular monitoring committees which meet every 3 months. With that, the effect is that all of them are being released, or effective orders are being passed, or the DMs are being arrested. There are some constraints of lack of infrastructure, which Mr. Madanlal, you said that you would like to put in a word from Barnala, right? We had talked about what kind of infrastructure that we do. 38 matters. Mr. SP Singh is here. He was the district judge at Gurugram before coming here. I happen to be the inspector at Gurugram. Interestingly, as pointed out, we have 1.60 lakh cases of Section 138, being the hub of Haryana. Multiple cases are filed by finance companies, big companies, on EMI basis. One check bounces, they have 5, 3, 4, and the number of complaints have gone up was the lack of service. Many of these people, the persons whom the loans have been given, they are not residing in the state of Haryana. So service is not being affected, and our courts have got clogged with this 1.60. Regular pendency is 1 lakh, 1.60. We have around 20 magistrates who got 16,000 cases trying to handle this way. And one way, the last permanent Lok Adalat, the present district judge, the remedy which we proposed was we called their representatives. And we said that you settle these matters because you have lodged 20 complaints against one poor person. And you are clogging our system, neither you are getting service affected, somebody is taking UP, somebody is taking. So this is one aspect definitely which we can work on. The police authorities, as usual, are not very helpful. We need to put some system in place to train them for the present. Some of them are very young. We need to give them some kind of a employment base. Lok Adalats, which we are organizing on a very frequent basis, we are running out of work. So therefore, it is the same set of insurance companies. The insurance companies, if we maybe reduce one instead of, it would maybe help us to get more work and more genuine, what we call settlements. Because it's the same set we have a Lok Adalat at the High Court level also. So it's all overlapping. They find it, we're not finding enough to come on board. So the insurance companies then also start taking it, we really can't push too much to them also. Otherwise, if it's too often to them, they also are not that open. So we are now, of course, the numbers game is there, but the number game is, if we look at these are matters which are just put and eventually will anyways be decided. Many of them are very summary kind of procedures. The balances, the big money part is with the MACT people. And if we can keep these insurance companies, they are the ones we are dependent upon. So I think we've reasonably covered at least my part of whatever I could, and rest I'm so thankful for all of you, for all the patient hearing, and I'm sure there are a lot of things that we've not covered also, but well then.
We've had an extremely insightful and thought-provoking address in the morning by Justice Khanna that you shared with us, and there's a lot to take back home. But we are equally conscious that there's a lot of food for thought, some self-audit to be carried out. So it has the concept Legal Aid Defense Counsel system, the LADCS, it has a bit of a background to it. All that as regards the issues concerning competence building of our defense counsels, you see their visits to the prisons, the legal awareness programs that are to be run, and the other challenges we are faced with. So, the legal service authorities in India provide legal services to the convict, the accused in custody, and to all of those who are entitled and eligible thereto in terms of Section 12 of the Act. So, all of this, that those people were permitted to carry on with their private practices, and of course these matters were marked to them. But over a period of time, it was felt, it was experienced that it wasn't working too well, primarily owing to lack of accessibility and availability of the consuls. Their priorities perhaps were different, and lack of interaction with the clients, updating the case status, not being able to generate faith and confidence in them, and of course some ethical issues. That's what the background is about. So that's how we switched to the remedial method, you see, in terms of the public defense system, on the same terms and the lines, and that's how the LADCS scheme was approved, and that's where we are today. So, of course, that's not the end of it. We have to take it forward from here, particularly to keep pace with the challenges and the times, the changing times, so that we are able to really take this institution forward. See, in so far as this capacity building program and legal aid defense counsel, a couple of things, I think, with the assistance of a few Secretary Dhalsas who are present here personally and the member secretary here, we were able to call out a few things which perhaps would be beneficial to all of you. The point for discussion is the inputs can be gathered on the types of subjects to be included in the training program. There are two ways to address this. One is that, of course, the induction and the training programs for the LADCS, and the tools as to what is the method and the module, what is the formula to impart that training. Now, even Justice Khanna in the morning session briefly touched on this, that even the pre-trial and remand assistance perhaps is the key, because that's what effectively determines, as regards the custody, the person's, the time he spends in custody. So, in my opinion, perhaps the pre-trial representation is critical in criminal jurisprudence, especially during remand and bail hearings, where the outcome can significantly impact the accused's fate and time in custody. And of course, we need to train them in so far as the prosecution's demand for, you see, be that the judicial or the police custody, to be well equipped, to be well aware, and keeping pace with the changing times and the laws, so that they are able to effectively oppose this. Because this pre-trial stage, as I said earlier, is going to be very crucial. So, you see, in one line, if one has to sum this up, is this, that the legal aid defense counsel should be trained to effectively argue against unnecessarily police and judicial custody, safeguarding the rights of the accused during pre-trial detention. So, how far we've been able to do it, and what sort of a training is being imparted. And again, there's another idea which I would share with you, that we were in Haryana able to connect the LADCS with the trained judicial officers in the Chandigarh Judicial Academy, and they benefited a lot from that. And possibly we can do this and replicate the same module in so far as the PLBs are concerned, because they are part of the extended family. So once they are connected, the required training, be that you see in the police stations, be that you see in the prisons or anywhere else, if they are well equipped, perhaps that would take things forward. So sentencing advocacy is yet another area. Now once you see an accused is convicted, the focus shifts on minimizing sentencing. So we do not know whether the assistant legal aid defense counsel, one can understand in so far as the chief legal aid defense counsel is concerned, the criteria is he has to have 10 years of criminal practice and minimum 20 or 30 sessions trials, and that's how he becomes eligible even to compete for selection. So how about the assistant legal aid defense counsels? So if we have to look at it from that standpoint, perhaps this would be a key area, the sentencing advocacy. Once the accused is convicted, the focus is on minimizing sentence. So mitigating circumstances is another area. They need to be trained as to, well, it is their research and their regular interaction with the client, trying to know the best possible in the given situation, how to present mitigating factors such as the accused's background, mental health issues, and secure, of course, the lighter sentence. And then alternative sentencing also, advocating for an alternative sentencing option such as probation, community service, etc. And then tools also, the tools for training. So that's what we discussed. So a training manual for legal aid defense counsels can include sections on criminal law, courtroom advocacy, and ethical standard focusing on key areas such as the right of the accused, case management, and handling vulnerable populations. It should provide practical guidance on pre-trial and post-trial processes, legal research tools, and using technology for case management. So this is the paper that we prepared and we'll share it with you before we leave. And there is a lot one can say on this, but I'll quickly cover a few of the key aspects which will be thought-provoking, and you can dwell on this later. So interactive workshops, the hands-on workshops that focus on practical skills like courtroom advocacy, cross-examination, and legal writing. The mock trial and simulations is again something very important. We've been doing it in Khalsa quite frequently, and that has yielded results. So we'll share those details and data with you. And then e-learning platforms. So online courses, webinars, videos, lectures that offer flexibility and accessibility for continuous learning. That's another aspect. The mentorship program, the case study discussions, skill-based assessments, legal research tools, and role-playing exercises. And of course, the electronic evidence. Now that's something important because the indivisibility today, what we are faced with, and the litigation is multiplying by the day. So this is electronic evidence, DNA, and forensic science. Why it is needed is the criminal cases increasingly, as I said earlier, involve electronic evidence, CCTV footage, digital communications, DNA, and other forms of forensic evidence, fingerprints and ballistics. So the training focus, of course, we need to develop a little sharp so that they are well equipped, well trained to meet the challenges every now and then in the court. So now before I move on to the further area of discussion, we have about 8 of the secretary DLSAs who are here. We interacted with them a couple of days before we came here, and of course people from Punjab and Himachal also. So I would bounce, this thought and ideas to you in case any one of you, since you are working at the ground level, directly, continuously connected with the secretary, the LADCS, if you could share some thought and ideas as to what practical difficulties are being faced with and how do you contribute to the competence building mechanism insofar as the defense counsels are concerned. Any one of you, please, if you could say a little on this.
Myself, Ritu, Secretary DLSA Kaithal. Lordship, during my earlier visit to jail, I found that हम LADCs के through या legal panel lawyers के through असिस्टेंस दे रहे हैं अपने प्रिजनर्स को, बट इन मोस्ट ऑफ द केसेस इनमेट्स को पता ही नहीं है कि उनके केस का एग्जैक्ट स्टेटस क्या है और क्या उनके लॉयर्स काम कर रहे हैं. सो आई कंडक्टेड सेपरेट मीटिंग्स विद LADC एंड पैनल एडवोकेट्स एट सब डिवीजन लेवल एंड आई हैव डायरेक्टेड देम, क्योंकि लॉर्डशिप मोस्ट ऑफ द केसेस में अब ट्रायल BC के थ्रू हो रहा है. सो इट्स अ प्रैक्टिकल डिफिकल्टी फॉर एडवोकेट्स ऑल्सो to tell the prisoners about the exact status of their case. So I have directed LADC कि during their jail visits वो rotation wise हर prisoners को कुछ ना कुछ उनके exact status of the case बताएंगे, like कि आपके केस में 6 witness हो गए हैं, 2 witness रह गए, next date पे आपकी final arguments हो रही है. With this small initiative of DLSA बहुत ज़्यादा satisfaction आया है हमारे inmates में. प्लस एक मैं LADC का और हमने एक और scope निकाला है जहाँ वो work कर सकते हैं. During one of the interaction with LADC, I came to know that one of the prisoner is again insisting for moving a bail application, which was not feasible at that time. So जब हमने reason पता किया तो पता चला कि उसका excuse ये था कि उसके 2 minor बच्चे घर पे unattended थे and there was no one to take care of them. So DLSA in coordination with CWC immediately rescued the child and found that they were not eaten since 2 days. So we sent them to for medical assistance, and later on they were shifted to CCI Karnal. Now both children are getting good education, और उसके बाद मैंने एलईडीसी को डायरेक्ट किया है कि आप जब भी रिमांड आवर्स में आप प्रिजनर जैसे ही एक्यूज लाया जाता है तो आप उससे एक शॉर्ट कन्वर्सेशन करें अबाउट देयर फैमिली मेंबर्स, और अगर कोई भी हमारी तरफ से उनके फैमिली मेंबर्स को असिस्टेंस दिया जाएगा तो हम देंगे। दिस इज माय थैंक यू।
See the public defender system from the old assigned counsel practice.
जी लॉर्ड।
So we would require your very genuine and honest response.
Yeah, sure.
Is this really working?
Yeah. So they are even taking my opinion about their case. They are discussing legal questions with me. So I think this is a good initiative.
Because you see, they all know it, that this is a committed designated cadre for full-time salaried defense counsels. This is unlike the previous era. So we would want your genuine inputs here, that in case there are certain areas which we need to plug and take cognizance of, so don't be hesitant. So I had a chance to interact with another officer, Amit Verma. He's here in the audience, please.
Myself, Amit Verma. I am posted as Secretary TLSA District Rewari, Haryana. Lordship, for the purpose of capacity building of the LADC councils, I have explored something which I would like to share with you. In the state of Haryana, there is a concept called study circle. Every month, London District and Sessions Judge selects a topic and assigns the topic to 2 judicial officers, one from the additional session judge rank and the second officer is from the magistrate rank. They prepare a write-up on the said topic, including the latest landmark judgments. And then a meeting is convened with the London District and Session Judge, and that write-up is circulated with the judicial officers only. When I collect that write-up, I take it to the LADCS councils, and I convene a short meeting with them for half an hour or so. We have a cup of tea, and I share with them the write-up consisting of all the latest judgments, and I also listen to their problems, and so I try to solve them. Monthly workshops for the stakeholders. Like in the month of September, a workshop for MACT cases was conducted, wherein all the investigating officers dealing with the accident cases, the DSP traffic was called, and I also invited the panel lawyers as well as LADCS to attend the workshop so that they can be updated with the latest case laws and all these things which are required to be done in the MACT cases. Although they are not currently dealing with the MACT cases, but just to keep them updated and to keep them connected with the working of DLSA. During the month of August, we conducted a workshop for POXO cases. During the month of July, a workshop was conducted for JJ Act cases and the new laws, the BNS and other new laws. So the LADCS councils are always joined in these said workshops so that in their capacity building.
For pre-arrest, remand, during trial and appellate stages. So how far the system has been successful and the role played by not only the Chief Legal Aid Defense Counsel, the deputy in the system?
Successful. Because earlier there was a concept of panel advocates. We used to assign cases to them, and these advocates used to deal with private cases as well as the cases assigned by DLSS. So there used to be conflict of interest. Right now, the LADCS Council are given this exclusive task, and they are taking good care of it. They are filing the bail applications, they are citing judgments, and they are taking help of Law Finder software, and they are
To the Legal Aid Defense Councils, please. We'll solicit your views and ideas on it, because that's what the whole purpose is for which we assemble.
We started LAC office last year in 2023, and we have already started this study circle program last year. So we conduct monthly meetings every month with LADC councils, and quarterly meetings are also held by me. So we evaluate the working of the legal aid defense councils, and we assign a topic to the one legal aid defense council rotation basis to discuss important topics of law and important judgments. So it's very fruitful. One thing is, I would like to apprise this August gathering. Lordship, initially the legal aid beneficiary take the legal aid because they know they would get the bail if the bail application is filed by the LAC council. But at the fag end of the trial, they engage private advocates, sensitizing the legal defense counsel to instill confidence in the legal aid, this beneficiary, that is the under trial prisoner, so that they should continue with the Legal Aid Defence Council. And for that, they have been directed to interact the case law and the facts of the case with the accused before the date of the cross-examination, so that they can take the inputs from the accused, and in this way we can instill the confidence in the accused persons, and we can improve the working of this.
Succeed in so far as introducing the plea bargaining to reduce the workload, be that taking the matters to Lok Adalat after we are able to apply our minds and decipher. This is actually resolvable.
But see, we created awareness regarding plea bargaining, but I think it's not that successful in Chandigarh, because
so moving forward from here, yet another area where perhaps we can spare a thought, this technology integration. Sister Lisa perhaps will dwell better on this, but this can really work wonders, because what we've been able to assimilate is the technology integration in the legal aid, even the PLBs, so that they're able to reach out to the most marginalized and those who are completely unaware that anything of this sort even exists. So no matter from which standpoint and perspective you look at it, eventually, to my mind, it will all boil down to one single sentence, that's awareness. 90% of them are possible, 80% of them is debatable. They have no clue that anything, be that the schemes, be that, you see, this, the other programs that are being run, or possibly the inmates also. So they have possibly no idea. Now, be that through the electronic print or the other mediums, or the radio jingles or anything else, that's perhaps can do better. But again, coming back to this, how far can we benefit from the technology integration? That's another area where you can think, particularly Secretary DLSA's member secretary. So, in case we can actually tap this resource so that we can connect, see everybody, and even the PLBs for that matter. They're part of the extended family, they have their own inputs to get. Things can really work. So again, coming back to, you see, the legal awareness programs in prison with special focus on LADCS and sharing success stories. There are quite a few, the member secretaries here. We have those printed formats with us. Things have really worked. And some unbelievable stories, we'll dwell on those. So all that I wish to share is, when Legal Aid Defence Council visits prison, they should proactively inform prisoners about their legal rights and services available to them through so-and-so. That's quite normal. You see, another suggestion was that notice board should be placed in a prison, legal aid clinics clearly outlining the services provided by LADCS eligibility criteria and the procedure for availing these services. So I had a chance and occasion to visit a few jails in Amritsar before me, Brother Sandawalia. So it wasn't there. Things were lacking in a district as important as Amritsar. In fact, two of the ladies in their 70s were sitting on the floor, and the concerned officer was present in jail, and those two ladies were just picked and lodged there, and they were there for over 40-50 days, and they had no idea what for they were brought there. And later, the district station judge who accompanied me, Madam Randhawa, and we inquired, because they were hauling actually, because for 40 days they were not even told what wrong they have committed. So the only explanation was 107, so which is bailable or something. So 50-60 days had already gone. The local deputy commissioner, I have no hesitation to say, the local deputy commissioner he was speechless, and so was the officer. And in about 2 hours' time, they were released and dropped at their home. So until and unless you see some sort of a display, some regular visits, some personal connect, some interactions, if all of these is ensured, perhaps things can really work, and that will, you see, improve the system. And again, visits, I've already said that. This is a disbursement of victim compensation and provisioning of other assistance to victim. So this indeed is, I would say, is to process applications where the delays or gaps occur in the system.
Amongst the litigants as well as counsels with regard to implementation of victim compensation scheme, and probably it is not in Haryana only, rather it is across the country. Firstly, there was a scheme which was not meant for, which was not covering female victims. Subsequently, part 2 of the scheme was implemented, but in this scheme, there is no scope for payment of compensation to victims of accident. There is a specific bar in Haryana victim compensation scheme that the victims who have suffered injuries in motor accident are not eligible to receive compensation under victim compensation scheme. Now under section 161 of Motor Vehicle Act, central government has implemented a scheme in the year 2022, but the quantum of compensation being paid in that scheme is not commensurate to the quantum of compensation is otherwise being paid by Haryana Legal Service Authority. This confusion is generating a lot of problems. In addition to that, Haryana compensation scheme is also debarring the assessment of compensation for victims in POXO cases. Since POXO Act provides that the compensation is to be assessed by the court itself, many times it has been observed that the courts are not paying adequate compensation. In that eventuality, even appeals are being filed before the State Legal Service Authority for announcement of compensation. It happened in several cases that writ petitions were filed in Honorable High Court, and in Honorable High Court it was debated that instead of moving in writ petition, the victim should come before state authority. So the appeals were filed before Haryana State Legal Service Authority, but since this victim compensation scheme is debarring any compensation, then another leg of litigation is being created. Now, it has been, while hearing those appeals, I have advised that any victim who is not satisfied with the quantum of compensation paid to him, he has a right to appeal in under BNSS. This kind of confusion, my lord, it will be better that if for all kind of victims there is only one scheme, in lordship, there should be one forum for payment of compensation. Under central government scheme, the body which is providing compensation is different. Under Haryana compensation scheme, it is the Legal Service Authority, and in POXO cases, it is being assessed by the courts. So if this kind of anomaly is wiped out, I think there will be better mechanism for payment of compensation to the victim.
See, taking a cue from here, I would say since the state of Punjab, Himachal, Haryana, UT, you all are here, we can take the lead and start this study. So this for sure would ensure timely disbursement and better access to justice for victims. And this perhaps would be an eye-opener. We've examined this in depth, and as I said earlier, this as a repeat value, so I'll say it again, this was truly shocking. This is the amount of applications that are piled up, and more than that, these are those people who have somehow or the other, with the aid and assistance of the paralegal volunteers or the legal defense counsels, that moved the applications formally and they're pending. Majority is still unaware. They have no idea this is what they are entitled to. So that's where the awareness, you see, would become extremely crucial and can do wonders if at all we look at it that way. So the other aspect is the provision of other assistance to victims. There's another quite a few areas we would like to underscore. The victims can belong to various vulnerable categories, as you all know, and know better than most, that children, women, senior citizens, and disabilities, persons with disabilities, and those suffering from mental illness. Because it's not just about, you see, one problem we are faced with. Each group would require a tailored approach to ensure that their specific needs are addressed effectively. So we need to, you see, dive a little more, dwell a little further, and then see how we can address this. Because at the surface level, it appears that, well, assistance to the victim. Now, be that, you see, the children, the senior citizens, people with disability, and those suffering from mental illness. But, see, it's not fit-all kind of a situation. You will have to devise a mechanism to address the need, because it's varied as to how we can address. So, again, quite a comprehensive work done on this, and we'll make sure that we share with you the material that we've collected over a period of time. So this will benefit one another. And of course the trafficking and the acid attack victims and the sexual assaults, so all those things, the details to be carried out on that. So having said that, so insofar as this is concerned, all that I would say in the end is that by following a research-based approach and involving experts in the field, legal aid authorities can become a central figure in ensuring we were designed to ensure diversity and inclusivity. The volunteers could be selected from a wide range of so and so. And we did flag the teachers both serving and retired government service, students who are pursuing law courses. So in Haryana, quite an area which I would like to share with you is educated prisoners serving long-term sentences, not directly educated. So as Justice Khanna said in the morning, you see somebody who spent 8 years, 10 years, he's as good as any trained practitioner, he knows his rights and everything. But the moment we involve him in something like this, not only that we put him on a rehabilitation course, we give him a purpose, there's some sort of acknowledgement and appreciation, so he too can help, particularly when the SETI DLSA is the regular visitors to the prisons and the jails.
PLBs. That's the best indication that they have faith in us. If the prisoners have faith in us and they promote you, that sends a very good message. With regard to the student PLBs, my experience has been mixed. In fact, the teachers themselves say my students lack interest. But where I found their use is extremely helpful. Don't take student, paying you. We have paid it, and I also made it a point to say that these are lawyers selected by us. The Secretary DLSA, Chairman DLSA, etc., are all judicial officers. So in a way, judicial officers are trying to give you best legal aid possible. And they are in touch with them. So where on earth can you get this type of thing? We have to also provide second opinion. Second opinion is very important. We have to interact with the family members because most of us don't have so much time, but we'll have to interact with the family members and ensure that, as it was pointed out, the time period is sought to be reduced from 7 days to 3 days. A private counsel, because he's paid immediately, he'll go the very next day. But we have our constraints because of the caseload and workload, but we must reduce it to the bare minimum. If the counsel is not able to go immediately, let the assistant go. Or somebody else goes over here. Legal aid clinics in the jails serve a big purpose. There I found there was lacking. We have to now either do legal aid clinics, say in the morning, when the prisoners come out for the breakfast and things like that, or the first meal of the day, their interaction must start, and probably speak to them with politely. We did some other things, like I suggested. Some places the prisoners didn't have money to buy some good things once in a while. They have. We said, okay, somebody can, for even telephone, there was not there. We can ask some NGO to give them money, to help them give money. If after all, what is there? A soap or some sweets, or sometime for once in a month or something, or maybe a snack which he wants to have. Why not? Why can't the NGOs do that? It's after all, he's probably, don't hate the criminal. Maybe the crime is something which we all do not accept, but don't make it so personal to the person concerned. I was a little confused about the scheme with victim compensation scheme. Is it in the case of the sexual harassment, etc., this problem is arising, or the Haryana government has framed a separate scheme altogether?
Haryana government has framed a different scheme, but there are 3 schemes. In fact, one is meant for sexual assault cases, another is for general crimes, and the third one is motor accident cases.
So let's not confuse the 3. As of the first scheme is concerned, there may be slight overlapping, but in that case, it's for the state government really. You can send your comments to the state government because they should not be. After all, money can increase. Payment of compensation money can increase if the state government's fund is more. Why not? It's good. But some mechanism can be found, we can then write to the state government that please club it or add it up with that instead of having multiple applications. And I think governments will be very happy to do it once you inform them. They'll be very happy to change the format of the scheme.
We can take this up because
that can be done. MACT is entirely separate. Your other scheme or any other thing will be completely separate.
Lordship, I have already spoken to the concerned secretary. Since Haryana government was in election mode, so after election he has assured that he will
the other last thing which is I think across the board which I found was there is lack of communication between the councils and the accused. This is something which we will have to do, probably with the video conferencing facility now available. I have also told the jail authorities, asked jail authorities that most of the cases they immediately be talking to the on the video conferencing to the by the jail inmate with counsel should not be counted as one of the chief or deputy chief or even for that matter assistant. It's good for them because they get a lot of answers. When he read out, this is the statement, he'll say, ये चीज़ बोल रहा है ना, ये गलत है, इस वजह से गलत है. क्योंकि मैं वहाँ पे था, इससे पूछिए वो था, 161 statements must be given to them. You must read out the 161 statements. So to get their response, they'll tell you what exactly, where is he twisting the facts? By over-implication or by saying wrong facts, because he wants to put the blame on you rather than blame is on him. He was, or the accused or the victim itself was responsible. Of course, we are not saying that he's absolutely saying he's
just was discarded because people who are carrying on with the private practice, perhaps this was either not their.
I don't know. In the High Court, we are still continuing with the whole. In the Delhi High Court, I can tell you, the success rates of private counsels is much higher compared to private counsels. Maybe also for the reason the private counsels are picked up by those who have bad cases. But there have been also occasions where there are multiple appellants in the High Court or multiple, in case of acquittal. One or two of them will choose a very high-paying counsel. Most of them will choose government advocates. Because that is true. Delhi High Court, I found the youngsters who are coming in who are doing excellent work, much better than the private counsels. And the success rate
is because it's 10 years of standing.
We have to continue. Look, this everywhere I have gone, every judge I've spoken to has been positive about this scheme. So I think it's a right move. It's the right step. Only thing is, we must not become complacent. We must not accept. It has to be work. If we have to be vigilant, mentoring and monitoring is constantly required for these kind of successful.
Before we end, I must thank Chief Justice Shakdar, brother. So for all the warmth and the hospitality, and I think it's been an absolute privilege to be with you all. A lot to gain, a lot to learn, and hopefully we'll meet up soon. Thank you for the opportunity.
Sorry for the inconvenience. Thank you, Lordships, for the insights. Now, I request the Honourable Dignitaries and learned participants to kindly assemble in the back lawn for a group photograph, please. This will be followed by a short tea break, and we will reassemble in 15 minutes thereafter. Thank you very much. Honourable Mrs. Justice Lisa Gill, Judge of the Honourable Punjab and Haryana High Court, and Executive Chairperson of the Chandigarh Legal Services Authority. And her ladyship will be assisted by Learned Member Secretary of the Chandigarh Legal Services Authority, So kindly join me in welcoming her ladyship, please.
Grateful to Justice Sanjeev Khanna, who has provided this opportunity for all of us to come together and share some of the best practices we have been following, the difficulties which we have been facing, and the steps which we would be taking. And I do have that onerous task of winding up as quickly as possible. So therefore, let me share that whatever we had prepared and the PPT, etc., we would require permission to circulate that, the soft copies. Well, that's technology. Such gainful insights we have got since the morning. Justice Khanna has flagged almost all the issues, and thereafter the presentations by Justice Sandawali and Justice Palli, and very well associated to our theme, that is outreach initiatives and utilization of digital platforms. The law is there, the rules are there, the regulations are in place, but what would be its use if the beneficiaries aren't aware of it? In fact, if the stakeholders are not aware of the entire steps with the benefits which are available. For that matter, may I say, not only beneficiaries, at times it is felt that even the officers are not aware of all the schemes which are available, the benefits which can be given to the interested persons. So herein comes the need for outreach initiatives, need to create awareness. The scope and ambit of the sphere is so immense because in fact if we look to it, there are no boundaries. As far as this act is concerned, a person with a vision like Justice Khanna has also given so many, that the scope is unlimited. What all we can in fact do under the aegis of this act. So keeping that in view, we have to first and foremost see that there has to be a multi-pronged approach. We have to enroll and enlist the help of a number of authorities. The panchayats, of course, the police authorities, the administration, civil administration. Not only that, schools, colleges, educational institutions, hospitals, all these institutions, once we do need to have them on board to see to it that the programs which are there, they need to be put into action. There are a number of, as far as Chandigarh is concerned, if I may share that there is a mobile app which was launched, Salute and Share. That's a mobile app, Android and iOS, which is giving out a list of the initiatives, the benefits which are available to all these citizens. And for that, great amount of work has been done. Mr. Surinder Kumar personally has been overseeing all these, this project particularly. And for that, as Justice Khanna said, we had enrolled young students because they are very savvy with technology. So they would go to, Chandigarh only has 21 villages, so the benefit is that the area is limited over there. So these children have been going and they have been even helping out senior citizens. They've been showing them, because even a senior citizen today as of now has a mobile. They are showing to them that this is how you can access, this is what can be done by you. And another aspect where technology comes in, if I may share, I'll just be digressing from, as far as awareness is concerned, so this is in relation to the POSH Act, Protection of Women from Sexual Harassment at Workplaces. We incidentally had a program some time back in the High Court of our women employees. Surprisingly, majority of them are not even aware that these provisions exist. And this is in the High Court. So here and after that, a number of programs have been held at various other places also. But this is only a tip of the iceberg. And a number of issues have been flagged today. And regarding use of technology for our LADCs, sharing, etc., I do not think that we can undermine the importance. You have, I think now, a mobile, this app where you are uploading the status, the case status, etc. Everything is being updated. That is something we are taking care of now, so that status at least of the cases is updated. And may I flag one more issue regarding the awareness of the right of the accused at the remand stage. At Bathinda Brothers, Sandavalya might know, round-the-clock initiative had been started. That if a person, an accused is hours, beyond working hours, it's not that the legal aid counsel would not be available. A roster was prepared that for those particular hours, that counsel would be available. So this is something which had been started and I think can be replicated at other places too. And regarding this, I am again, as I said, I'm not going by the script that we had prepared. So therefore, the conduct of these need-based awareness programs and collaborations with other institutions, we will actually have to take immediate steps to enlist the help of these institutions too, and administration we will have to rope in. At Chandigarh we have prepared a small video for awareness regarding drugs, and the target group is children, because alarmingly we have come to know that it is the age group of 12 from which they are started to be targeted, and schools are one of the most fertile places where these children are unfortunately targeted. So we have prepared a small video which is now being played in Chandigarh at public places, and we have tied up with certain schools where our volunteers are going, they are being played. We are asking the teachers to play a proactive role so that the teachers would see the signs. And for that matter, we are requesting that it should also be percolated to the parents, because parents need to know. And these are little measures that we do need to take, we are taking, and this video also, rather than playing it over here and bother all of you, we would be sending it, but the request is, please do go through it. Please look at it, listen to it, and if you find it is useful, please replicate that. And it does need to be publicized. It is not very, people are not very well aware of it at all. And the saving schemes which are there, the booklets sometimes which are given, or even the soft copies which are sent, over there we can have it incorporated. We can tie up with the banks also. It can be done over there. In the hospitals, they are there, but then to our experience, it has really not been helpful, sir. It has been there, the helpline.
It was launched by the NASA last year. So we are making awareness about this portal. So we have suggested that we can issue advertisements regarding this portal in the savings, small savings scheme passbooks at the back cover with the help of the post offices. And in India, the vaccination cards are issued to newly born children when they are vaccinated in the primary health centers. So we can also inscribe this NALSA helpline number 15100 and this legal service management system, so that the needy and the deprived sections can apply for the legal aid through this helpline number, and they can also apply for this NALSA portal and the helpline number. So we have to make two suggestions. so that it would improve the access to justice to the deprived signal society. In Chandigarh, Lordship, people are availing legal service through this portal, and we have also conducted training program for the advocates so that they regularly update the case status on legal aid case management system. Recently, we have conducted training programs with the help of the NALSA moderators, and the advocates have started updating the case status on this portal. We have also started the process for installing display cards at various schools, colleges, post office, hospitals, police stations, as per the direction given by the NALSA recently. We are also incorporating the helpline number on the emails which are sent by our office, so that every department should have the knowledge that this helpline number is functional all over India. So these are the steps which are being taken to disseminate knowledge about these helpline numbers and the portal.
May I just emphasize once again the importance of collaboration and coordination with various other agencies. This can very well be flagged by the example given by the officer from Ketha today. So until and unless there is collaboration, coordination between the legal services authorities and the other wings of administration and NGOs as well, the entire benefit as is intended may not percolate. And the emphasis on mediation, rightly there, sir, as I would suggest that there has to be a lot of coordination between the various committees of the high courts as well, so that there is a concerted effort. Children with disabilities, mental, intellectual disabilities also, there is a lot being done by the legal services authorities, at the same time by the juvenile justice board committees. So if there is more coordination, we can achieve better results in any case. I would ask any of the officers here if they have any suggestions on this aspect.
Under the guidance of Honorable Executive Chairman and Honorable Member Secretary, DLSA Mewat has launched one campaign, Swasth Beti Surakshit Bharat. Under this campaign, we acted in coordination with Whisper Ultra and Education Department. We conducted awareness programs in several schools, guiding the girl students about the menstrual health and hygiene. And we have launched this campaign in the month of September, and we have covered till 8 schools. And we have distributed around 2,500 packets of sanitary napkins to the students, and have removed all their misnorms and myths about the menstrual health. We are using digital media as well. Through PPTs, we are explaining the concept to them. And leadership, this campaign is getting so much publicity in Mewat that we are getting calls from private schools as well to conduct such programs in their school also.
That is wonderful, and you should not desist from using technology at all, because that's what it is required to be. I mean, if we don't use it to the utmost, then we'll be failing. Yes. Congratulations to you.
Thank you, Leadership. Thank you.
And Leadership, I'm Shania Gupta, CGM, District Legal Services Authority, Narnaul. Leadership, we face a very common and peculiar situation in Narnaul. Actually, there are some children in slum areas, and they were deprived of their right to education, as their parents belong to migrant class. They are from MP, UP or Rajasthan, and working class. So one coordinator of the private school, who is also running the NGO, they approached me for help. Then I conducted the meeting with district education officer, and we appraised the principals that they should not deprive the children their right to education under the Act, as they are also liable to the admissions. Leadership, thereafter, on the direction of the district education officer, some staff of the education department went to the slum areas along with the PLBs and legal aid councils deputed by myself, and there 42 children were identified who were not getting admission in the school, and it was also found that around 50% of them does not have their Aadhaar cards or the residence proofs. Thereafter, on the direction of the district education officer, these children were sent to the government schools for admission. But despite that, the principal of that schools, they are reluctant to give them admissions by saying that the parents of the other children are not feeling comfortable by making these children sit with their children. Then we try to meet those parents and convince the teachers and the principals to make them understand that they are also the children who have the right to education. And when we impressed upon, then finally those 42 students get the admissions in up to 6th class in government schools, and 2 girls got admission in 9th class. And thereafter, Lordship, around 5 children again gets admission from another slum area, and 10 to 12 children again get admission from another slum area.
That is the idea. With such good work, wonderful. And we might may I take a minute? Sex workers. Much work had been done, and they had similar stigma that was they were facing ostracization, and all their Aadhaar cards they were made and they got admission in schools. So it's just, if I may say, it's a passion. We'll have to work with the passion. Take it up not as just a task we are supposed to do, but something that it's a responsibility and a duty which is cast upon us. And if we do have the opportunity, we are placed in such a situation that we are getting the opportunity to do something, we should use it, we should do the maximum that we can. That is what I would like to say here. And of course, please continue with the good work, and any suggestions you have, do not hesitate.
Digital display boards. So in Himachal, for the last about 8 to 10 years, we call something as the ideal time. Then before the court starts and after the court is over. So from, let's say, 9 to 10, and then 1 to 2, and then 4 to 5. We display not only Nalsa, but all the other welfare schemes of the government, which are not political or anything, but they're for the general public. And I think its results are amazing. Because you look, I mean, you have to see someone is just sitting idle at the court page, just seeing the screen. And these things do set in your mind. Because visual media is the best media to disseminate knowledge, or it retains the maximum, probably the brain retains video the maximum. The visual media. So that idle time in all the courts, including the High Court or the District Judiciary. So that could be one of the mediums, if not already resorted to, we should be resorted to.
And not only that, even public places, bus stands, hospitals.
Absolutely.
Why not? We can have these displays.
But we have it in Himachal in the High Court. We have this for the last about 8-10 years. We've been doing this. That's what my suggestion was.
High Court, we are also having.
We have the mediation.
No, but we have that constantly that thing is ruling. Not many of these advertisements.
When the display board is not on, then that mediation clip is on, some other clip is on.
Yes, it
like
is.
Just as Joanne is saying, before 4 hours.
Before 4
Half an hour, 45 minutes.
During lunch hours.
During lunch hours.
Look at the jump from 7,000 to 18,000. 167 to 7,000, then to 18,000. That's a very positive sign. Oh no, it's not 7,000, it was 5,000 something to 18,000. That's a very, very positive sign. There's so many success stories we have heard, and and it was such a positive sign we are writing up. That their things are going to be much brighter, much better. The future is something we have to look up to. This was not meant to be criticism. This was meant to be a self-evaluation, and with the hope and desire. So much.
Thank you. I request the permission from the chair to kindly declare the conference closed.
Yes, please.
Thank you, sir. Thank you, sir. We extend our heartfelt thanks to all our distinguished speakers and participants for their valuable contributions and insights. Your presence and involvement have truly enriched our discussions. Thank you once again for being a part of this significant conference. Safe travels, and we look forward to seeing you at future events. I thank you once again on behalf of our learned district and session judge, Shri Jaswant Singh Thakur, who is also the chairperson of the District Legal Services Authority. I am Karan Pranab Singh, Civil Judge Chamba. Jai Hind. Thank you.